All right, we'll go ahead and get started. Good morning, everyone. The court calls CR 2021-001-294-001 and CR 2016-115-329-001. These are both State versus Jamal Pennington. Appearances, please.
Good morning, Your Honor. And Chica Marotta appearing on behalf of Kaylee Jenkins for the state on both matters.
Good morning, Judge Edward Molina appearing as the advisory counsel for Mr. Pennington. He's present in custody here at the table.
Thank you.
Good morning, Jamal King Pennington.
Good morning. Welcome, sir. This is the time set for the oral argument on the motion for change of judge for cause. I'm going to be Mr. Pennington, I have reviewed your motion for change of judge under 10.1 for cause, and I know you've marked several exhibits. The way we're going to start is you'll have, because it's your motion, you'll go first, and then I'll hear from the state, and then you'll have the last word. But sometimes it's helpful to know what my thoughts are in case you want to direct your comments and address some concerns I have. In looking at the docket, your motion for change of judge, and this is as to Judge Minder.
Hey, want to hear the most annoying sound in the world?
I believe is for a case that's already has a jury verdict. So although you filed this on September 21st and we have you here today, I have to ask whether this is moot. And when I look at Rule 10.1, you must file a motion no later than 10 days after discovering that grounds exist. So I would like to hear from you as to why you believe it's timely and why it's not moot since the jury's already rendered a verdict, whenever you're ready.
Yes, so when I filed the motion, I sent it on 9/18/23, and the reason was because at the time when I filed it is because my motions was not showing on the docket.
I saw that.
And then right when the court received, the very same day the court received it on September 9th, my motion started showing up on the docket.
Okay.
So it wasn't until I stressed to Molina in his office that I was having these issues. They contacted his JA and clerk of court. It originally started during trial. So I advised or told my advisory counsel that I wanted to file 3 motions with the court. He sent all 3 of them to the prosecutor, not this young lady, but DCA Jenkins. And Judge Minder.
Hey, want to hear the most annoying sound in the world?
Motion for reconsideration, motion in limine regarding the Iviana Horton, and motion for Willis instruction. Neither 3 of those motions are still not showing on the docket to this day. Now, after trial, I immediately, right after the guilty verdict, I immediately filed several motions. Motion for judgment of acquittal, Rule 20, motion for new trial, motion to change advisory counsel. Motion for reconsideration. It was roughly about 10 motions that I had filed immediately after. And those motions didn't show. He ruled on the motions, but according to Arizona Rules of Criminal Procedures, the clerk is supposed to file those motions and then hand them to the judge so he can go over them and rule on them and so forth. So I filed for 2 weeks. I went through my advisory counsel. and his paralegal. I also contacted the Office of Public Defender's Office, asking why these motions are not. I kept getting the runaround, so I filed this motion. And then once they received it, they started uploading my motion to the docket. What I also realized after I filed this motion, I started. I had my advisory council get the transcripts of the trial. He passed that on to my private investigator, Michael Stovall.
In the name of the Galactic Senate of the Republic, you're under arrest, Chancellor.
And a couple things concern me with Judge Minder.
Hey, want to hear the most annoying sound in the world?
And his mini entry. When he denied my motions for Rule 20. So I had my private investigator.
In the name of the Galactic Senate of the Republic, you're under arrest, Chancellor.
Come down to the jail, and we went through the entire trial, specifically Judge Minder.
Hey, want to hear the most annoying sound in the world?
Not knowing or couldn't give me a definition of hearsay. One thing he said in the beginning of the trial was it was hard to rememberize or cite all the rules to hearsay. And then when we asked him for a specific definition, he could not give it to me. So that was the beginning of the trial. Now, during cross-examination of Christina Ducoufle, I didn't catch it at the time, but Katie, I was cross-examining Christina Ducoufle, and regarding why was she discouraging Kimberly Dickinson from talking to us, even though Christina Ducoufle knew she was exclusively a defense witness. And she was telling Miss Dickinson that she, in capital letters, she did not have to talk to us after knowing she was a defense witness, and calling us, my attorney at the time, previous counsel, Mr. Vladimir Gajian.
Not ordinary troops, but Marines, a special force recruited from jails and insane asylums.
My private investigator.
In the name of the Galactic Senate of the Republic, you're under arrest, Chancellor.
We're shady, like sex traffickers, child sex traffickers. So I presented the Facebook records that I presented today as an exhibit to Christina Ducoufle. Well, she originally told me that Kimberly Dickinson, the reason she was saying this, she was just simply advising Miss Dickinson of her rights. And
so let me stop you here. We're here only on a motion for change of judge. So regardless of what people testified to or the interactions with your investigator.
In the name of the Galactic Senate of the Republic, you're under arrest, Chancellor.
I let you go on a little bit so I could let you explore that. I'm not seeing how it's relevant to your motion.
Right. I'm just giving you all the meat and potatoes. I'm long story short, in a nutshell, Judge Minder is incompetent.
Hey, want to hear the most annoying sound in the world?
Long story short, in a nutshell, Judge Minder is incompetent. Long story short, in a nutshell, Judge Minder is incompetent. Long story short, in a nutshell, Judge Minder is incompetent. And I have the three of the exhibits I provided you is saying that the Court of Appeals agrees with me and saying he's stupid and incompetent. I have proof here. Three of his rulings was overturned. And one of them is similar to my case. He was the Court of Appeals said that he abused his discretion and found evidence of domestic violence against a Hispanic when there was no evidence of domestic violence. They overturned and vacated. Same thing in my trial. I asked them for Rule 20 when the state rested because there was no evidence of counts 6 and 7. And he denied my motion. And in his ruling, in his minute entry, he said things like, Miss Barganier, I urge Miss Barganier to count 7. And I reviewed that her entire testimony, and not once did she use the word urged. I urged her or peer pressure. In fact, she said I never forced her or caused her to do anything.
Okay. So are the exhibits you marked examples of Judge Minder?
Hey, want to hear the most annoying sound in the world?
Some of his rulings being overturned by the Court of Appeals or Supreme Court or an appellate court?
I'm sorry?
Are some of the exhibits that you have marked?
3 of them. Exhibit 3, 4, and 5.
Okay. Any objection to me taking a look at 3, 4, and 5?
Your Honor, the only thing I'd like to know is that it looks like they're all civil cases, not criminal cases, but state has no.
Are they civil cases, sir?
That is correct. And what I would like to say, in one case specifically, he has weaponized the hearsay rules. In civil case, he doesn't even know that hearsay doesn't even apply. But it's the reason he denied Marcos Souza his petition on grounds of hearsay, and the Court of Appeals overturned it and said that he's wrong. So if he doesn't even know that in a civil case hearsay doesn't apply, what business does he have on a criminal case?
Okay. Do you have 3, 4, and 5? You have them, sir?
Yes.
Kevin, could you help us out? Thank you. Thank you. Let me take a look at these. So 3 is a family court case?
Yes. Yes, all 3 of them. I'm sorry, Judge. Yes, all 3 of them are.
All right, I've taken a look at number 3. Number 4 also appears to be a family court case from 2019. And Exhibit 5 is also a family court case. This one also from 2019. Also review 5. Okay. Anything else, Mr. Pennington?
Like I was saying earlier, in regarding him getting the hearsay wrong, 100% he's wrong when I'm asking Christina Ducoufle why is she determined. I'm not asking for her statement or her to talk about an out-of-state statement. I'm specifically asking her why is she deterring or advising a defense witness or discouraging a defense witness from talking to me, my private investigator.
In the name of the Galactic Senate of the Republic, you're under arrest, Chancellor.
And my attorney.
Not ordinary troops, but Marines. A special force recruited from jails and insane asylums.
Kaylee Jenkins objected and saying that it was saying it was hearsay. Judge Minder.
Hey, want to hear the most annoying sound in the world?
Asked me under, what context or the reason, and I said it's a prior inconsistent statement.
Mm-hmm.
And he thought about it and he said, in his opinion, he doesn't consider that a prior inconsistent statement. She's clearly saying that my private investigator.
In the name of the Galactic Senate of the Republic, you're under arrest, Chancellor.
And my attorney are
Not ordinary troops, but Marines. A special force recruited from jails and insane asylums.
shady like traffickers. Do not talk to them, even though she's exclusively a defense witness. So he got that wrong. And then another thing, I originally asked Miss Ducoufle, who is this streetwalker that identified me in the area and said I was a pimp and sex trafficking minor girls. Now, remind you, all those sex trafficking charges was dismissed in the middle of trial. 7 out of 9 I beat. So I'm asked, at first she said that she wasn't there when they allegedly showed her a photo lineup of me. And she didn't know what Kimberly Dickinson said about me or not said about me. But I submitted an exhibit of her grand jury testimony saying a worker in that area identified me. And I asked her, who's the name of that street worker? Kaylia Jenkins, the state of objected, saying hearsay. And I said, it's not hearsay. It's just, I just want the name. I don't know. I don't want to know what she said or I want to know what is the name of this street worker. And Judge Minter said,
Hey, want to hear the most annoying sound in the world?
sustained it. So clearly he should have never been my judge. 2 times he got those things wrong. And the final thing I would like to say, I did point out to you that there was absolute zero evidence of any sexual contact because first of all, I have a right to face my accuser. The accuser or the alleged victim never showed up. So it was only my son's mother who testified to this alleged threesome. And during her entire testimony, not once did she say she seen any sexual contact. Not once did she say I moved forward with my hips when I was allegedly standing behind the minor young lady. But Judge Minter...
Hey, want to hear the most annoying sound in the world?
allowed Kaylia Jenkins to say that in her closing argument. He allowed Kaylia Jenkins to prejudice me. Now, I don't have to object. He has a moral obligation to stop her when she's saying prejudiced things like, you know what goes on in that area, or you know why people are in that area. Remind you, sex trafficking charges was dismissed. I was only facing 6 and 7, which was sexual misconduct and molestation, saying I caused another to engage into the inappropriate act. So all sex trafficking was dropped in before she gave her closing argument. And she's talking about telling the jury, you know what goes on in that area. Why didn't Judge Minter...
Hey, want to hear the most annoying sound in the world?
stop her? That right there should have been a mistrial.
Okay.
So I seen all this when I reviewed my trial, and I realized either the Court of Appeals is correct that he's incompetent and he shouldn't be a judge, he's stupid, ignorant, or he's weaponizing hearsay to prejudice men of color, meaning he's a bad judge, meaning he's prejudiced. He's weaponizing hearsay for women in favor of women. And then on top of that, all three of these people are Hispanic and I just so happen to be black. So I'm saying that he's biased.
Okay. Thank you, sir. From the state?
The state takes no position on the change of judge.
Okay. All right. Anything else, Mr. Pennington?
I'm just surprised how Judge Minder
Hey, want to hear the most annoying sound in the world?
got this far. And it's really concerned, and I feel very sad right now, because this happened over 3 years ago, and if he can't get this right, why is he presiding over criminal trials?
Okay. Thank you, sir. Rule 10.1 requires me to first make a determination about whether you filed a motion no later than 10 days after discovering that the grounds exist. And the motion must state specific grounds for the change of judge and be supported by an affidavit. Allegations of interest or prejudice that prevent a fair and impartial hearing or trial may be preserved for appeal by making an appropriate motion. So in 10.1a, you're entitled to a change of judge if the party shows the assigned judge's interest or prejudice would prevent a fair and impartial hearing or trial. So what I'm hearing you say, first of all, is the motions weren't docketed. And my first question is, Mr. Molina, have you confirmed that the motions filed by Mr. Pennington were docketed?
I didn't see those on the
Okay.
motions that he mentioned.
Have you tried to work with him to make sure? I mean, we obviously want the docket to reflect anything he filed or meant to file. Just so we know the process, and I know the lawyers know, Mr. Pennington, you may know this, it's the clerk of court that actually dockets the motions, not Judge Minder or
Hey, want to hear the most annoying sound in the world?
his chambers. So even though it looks like we're all one big court, we all have specific duties. And so the clerk of court takes court filings and puts them into docket. Usually there's a delay between when the clerk's office receives a paper motion and when it actually is reflected on docket. They get so many pleadings every day. My experience is about within 48 hours. Is that fair? It's reflected on docket. Or longer. Sometimes it depends on the volume of pleadings they get. So there is a delay, but it shouldn't be, weeks or anything like that. And I'm glad you're paying attention because we need to make sure the docket reflects your motions. So my first question is, have you two gone over whatever pleadings aren't reflected in docket, made sure that you've handed them to a clerk so they can be filed? Okay. Mr. Pennington, have you done that?
Specifically, what are we talking about?
I thought I heard. Yeah, go ahead.
Filings from me. 16, 17.
Ones that's not showing up, the
Correct,
three
yeah.
ones. So she's asked me, what have I done to make sure?
Presented them to the clerk. Since then.
No.
No.
So I would just say, if you haven't done this already, I would immediately work with your advisory council and look at docket. It sounds like you have filed a lot of motions, but for starters, we need to make sure the docket has reflected any motions you filed and that they're ruled on. Does that make sense?
Yes.
Okay. So if you haven't done that and you feel like the system has let you down by not even reflecting your motions, please take a look at it. And then I don't know if you want to give them to Mr. Molina. To file, or if you want to hand them into a clerk, but certainly Mr. Molina can help you file any motion that have not been filed. Is that fair, Mr. Molina?
Let's make sure I have this clear. So anything that was previously submitted that's not reflected, resubmit for filing?
Yes.
Okay.
Just so that, I mean, we can't have a system where he believes he's submitted motions that are not reflected on docket.
Okay.
So if that's the case, I'm not saying it is, it sounds like it is, but if that is the case, I would just ask you to go over the docket with him and say, are there any motions that are not in here that you believe you've submitted?
That makes sense. Yes.
Because any argument you have needs to be considered by the court. Is that fair?
Yes.
Okay, so I would ask that you do that with Mr. Molina. As soon as possible, because I don't know if these are motions you submitted in the middle of your trial, motions you submitted after trial, but regardless, they need to be addressed by the court. Okay? Number 2, are there any motions that you believe are in docket but that have not been ruled on?
Yes, there are several that I just filed.
Okay.
I know at least 4 of them that has not been, ruled on.
And I do see several filings. There's a motion to convert, a motion to change advisory council. If these were just filed on September 26th, it looked like there were several of them that are at least docketed as filed on 9/26, then he still has time to rule on them. So if they were in that batch of filings, then he's probably still working on them or waiting for responses for the state. So just be aware that he's probably still got those.
Right.
Okay.
Yes.
All right. Okay. I reviewed the family court cases you provided. This is our exhibits 3, 4, and 5. I appreciate your position. I respectfully disagree with it. If you've been doing this job long enough, you get cases that go up to the Court of Appeals or the Supreme Court, and they sometimes don't agree with your rulings. And that's why they're there. They have a job to do too, and we have our job. So the fact that they have disagreed with some of his legal rulings in family court doesn't cause me to believe that under Rule 10.1, the fact of these family court cases, I don't find that it shows that he is prejudiced against you or that these family court rulings would prevent him from conducting a fair and impartial hearing. So I see what your argument is. You believe he's misunderstanding the law and misinterpreting it in your trial. But if your reason to ask the court to give you a new judge is you disagree with his legal rulings, that's not grounds that I can lawfully give you a new judge. All right. So I want you to know that I considered 3, 4, and 5. And if you disagree with his application of either, it sounds like you disagree with the way he applied the rules of evidence in these family court cases, and you disagree with some of his rulings, and you disagree with the way he applied the rules of evidence in your trial, there's a vehicle to get those concerns heard, and it sounds like you're well aware of that. You've already filed a motion for new trial. You may file an appeal. I would encourage you to talk to Mr. Molina about making sure you have that right to appeal. But that's how you get those legal concerns addressed by a higher court or on the motion for new trial by Judge Mender himself.
Hey, want to hear the most annoying sound in the world?
Does that make sense?
Yes.
Okay. So you've preserved that, at least as far as the motion for new trial. I would just encourage you, if you want an appellate court to review what happened in your trial, that you talk to Mr. Molina and make sure you've filed your notice for appeal. Have you a notice of appeal? Has he done that?
Sentencing.
Oh, I'm sorry. You haven't even had sentencing yet. It's not even ripe for it. I apologize. I know you had your verdict come in. You haven't had sentencing yet. So after sentencing, you would file your notice of appeal, and then a higher court could rule on whatever grounds you allege, things that he did wrong in the trial. Does that make sense?
Yes.
Okay. So the way that you get those addressed, it sounds like you understand. You have your advisory council. They'll walk you through the steps to make sure, even though you're representing yourself, you know what the law is and how to preserve those arguments. Okay. I'm not going to address the accusations, both in writing and orally, about Judge Mender.
Hey, want to hear the most annoying sound in the world?
I've known Judge Mender a long time.
Hey, Want to hear the most annoying sound in the world?
You and I part ways on our opinions of Judge Mender. I have a lot of respect.
Hey, want to hear the most annoying sound in the world?
For Judge Mender, and if you disagree with his rulings, that is absolutely within your right to do so. But I certainly don't find that there's any evidence that he's stupid or incompetent. I don't think the record bears that out. And I have my own respectful opinion of him and his work, and I know he works really hard and tries to get it right. So it's okay if we agree to disagree on our opinions about him. And I don't think addressing those is appropriate beyond the comments I have just made. Again, when you address things like there was zero evidence of sexual contact, the victim never showed up, the Judge Mender had a
Hey, want to hear the most annoying sound in the world?
moral obligation to do something. You're complaining of legal errors he may have made. And again, there are vehicles for that. And it sounds like you're aware of at least one of them by filing a motion for new trial already. And then you'll file your notice of appeal after the sentencing has happened. So if you believe that he committed legal errors, I can't, under the rules, not under Rule 10.1, change the judge. You can understand a lot of lawyers and people who are self-represented disagree with on both sides of the aisle with different rulings that judicial officers make, and that's okay. But we don't change your judicial officer assigned to your case because you disagree with one of their legal rulings, and 10.1 doesn't let me do that. So I have reviewed your motion filed on September 21st. I want to make sure you get everything addressed, and you and your advisory counsel, Mr. Molina, are going to make sure all of your motions are reflected in docket so they can be ruled on, because that's really important. But I appreciate your claim of innocence, and you believe there were legal errors made in the trial. That's okay. And there's a vehicle to get those heard, but it's not under 10.1. So I am going to deny your change of judge for cause. I don't find that the record shows that Judge Mender.
Hey, want to hear the most annoying sound in the world?
Has interest or prejudice that would prevent a fair and impartial hearing or trial. Is there anything else from the state? Anything else, Mr.